job in looking at the exhibits. So something that just says, we are sending you copies of exhibits A and B.
We think they're in there, but to
Right.
save time, here are some copies.
Right, exactly. So
I think these look fine.
they don't want them, so.
All right.
On the second question, the bill of particulars, in addition to the indictment, narrows it to this date. And I think the court had indicated in the instructions that what was focused was the ammunition found in the house on the date of, I think it was the date of the search warrant.
Yes, I thought it actually indicated on or about and all that.
Right, but I think given that there's been testimony as to other occasions here, it's really the day of the search warrant. There wasn't any evidence. I mean, I wouldn't want a situation where the on or about can then, because about is obviously a broad word, could refer to the 17th, where the jury could infer that the defendant may have removed a .22 from his house that was loaded, and therefore possessed the ammunition on that day.
The question, does this mean that the accused had to have knowledge of the object's location on 6/22, and then it says parentheses specifically?
Right.
So that would be no, because the indictment, in particular, it was on or about that date. Or, and then it goes on, or does indictment pertain to him having knowledge of its location at any point in time? Now, not at any point in time, but on or about June 22nd, I think would be a fair way of answering that question. That's what we committed to in the indictment and into the bill of particulars.
Well, I respectfully